Last week, we talked about copyright and how it's one of those things that everybody knows about, but not everybody quite understands. And we took a look at some of the basics, what copyright was, what's covered under copyright, some of the things that aren't covered under copyright. If you missed that video, I'm going to link up somewhere here, an info card to that video for you so you don't miss out. So if you're wanting a little bit more background on what copyright is before we get into today's video, you can check it out. Just a little bit of a disclaimer here. I am not a lawyer. The information that I've been providing in these series of copyright videos is from the research that I've done and information that I've found out. The second thing is I'm Canadian. And so the information that I've searched out is from a Canadian perspective. So if you're from another country and you're wondering about the laws of your particular country, what I'm presenting today might not be exactly what you're looking for. So today we're going to be focusing on 5 common misconceptions when it comes to copyright. Let's dive right in. Misconception number 1. If it's posted on the internet, that means it's part of the public domain and fair game to use. This is absolutely false. Not true at all. The term public domain refers to content that's not protected by copyright law. So public domain work are those items that can be used freely without getting permission from a copyright owner. However, like we discussed last week, content that has a physical form is automatically protected the moment that it's created. And that copyright lasts the lifetime of the creator plus 50 years. And guess what? That even includes things that are posted on the internet. It's true. Just because something has been posted by the creator on the internet does not mean that it's free for anyone to use. It is still protected by copyright laws. One of the best things that you can do is just err on the side of caution and assume that something is protected by copyright and get permission before you go about freely using it. Misconception number 2. If it doesn't have a copyright symbol, it must not be protected by copyright. Now, to be honest, there actually was a time when this was true. Way back before the 1970s, you were actually required to put the copyright symbol on creative work in order for copyright to apply. However, ever since 1978, that has not been the case at all. The copyright symbol is not required to be on the work in order for copyright to be valid. It certainly is good practice to provide that copyright symbol, but it's not a required thing for you to do. Misconception number 3. If I change someone else's work a little bit, I can say that it's my own. So here's the thing. No. Even if you write something that is similar enough to somebody else's work, and it is so similar that the average person would be able to tell, then you run the risk of copyright infringement. This doesn't just include writing. It actually includes all other types of work that are protected by copyright. And actually, you'll want to tune into next week's video where I will be talking about some of those works that fall into the category of derivative work, where it's not really copying, it's using bits and pieces of others, and how similar is too similar. And we'll take a look and see what the courts have to say about it. Misconception number 4. I've heard that I can use up to 10% of something before I can get into trouble. Well, believe it or not, this is actually not true. When you're working with quotes and extracts from somebody else's work, there's no magic number. Unless using quotes is clearly under the fair use rule, then your best bet is to, as always, err on the side of caution. Fair use allows quotations to be used in certain circumstances, like, for example, if something has been made available to the public. So, for example, quotes for news reporting and educational purposes. And finally, misconception number 5. If I'm not planning to make any money off of it, then it's fine if I copy someone else's writing or image. Yeah, so once again, I'm going to have to say, sorry, this is false. Just like the other situations that we've discussed, if you don't have permission from the copyright holder, then you always run the risk of copyright infringement. Of course, there are always the few circumstances that fall under the fair use rule, but for the large part, you're not free to use somebody else's work however you would like to without their permission. On top of all of this, if the copyright holder is able to prove that you actually negatively impacted them, so for example, they weren't able to make the money off of a piece of work because of something that you did, then you can actually be held liable financially as well. So that begs the question, why all of these super strict rules? Well, why not? These rules are in place to help protect content creators. Unfortunately, in our society, a large majority of people do not place the same value on creative work as what they do on physical things that you can physically see and handle. The truth of the matter is, whether you are using somebody's words or using their image or something along those lines, essentially you are stealing if you have not asked their permission. It's the exact same as if you were to walk into somebody's home, take their property, and claim it as your own. That's why my best piece of advice to anyone is, better be safe than sorry. Always err on the side of caution. Cite your sources properly when you need to, and always ask permission when it's necessary. I'm curious, what do you think? Is using somebody else's work without their permission the same as stealing physical property? Let me know what you think in the comments below. And as always, I am so appreciative of those of you that hit that subscribe button and help to support my channel. I look forward to seeing you next week when we conclude this series and investigate copyright in the court system. See you then.